Your name?
Yes, Your Honor.
Okay, so we can start a minute early. So why don't I give you the protocol, which I think Clerk Keneally probably has advised you of, but I'll do it just to make sure it stands. Then I'll ask Clerk Keneally to call the case, and then we'll hear from Mr. William Harrington. So the protocol, as I believe you understand, is we give you roughly 3 minutes to argue to us without interruption. If you wish to invite questions before then, you're welcome to do so. That questioning will begin with Justice Lenk as Senior Justice commencing questions. We will go by order of seniority. I will question last, and then if any justice has any further questions, I'll give them the chance to ask them. And you have roughly 15 minutes or until the questions end, whichever comes later. So with that, Neely, if you call the case.
SJC-12869 in the matter of an impounded case.
Mr. Harrington, good morning.
Good morning. May it please the court, William Harrington for the 2 petitioners. My clients are 2 municipal police officers who, after invoking their privilege against self-incrimination, were compelled by the Commonwealth to provide immunized testimony before a grand jury investigating a fellow police officer. Their testimony indicated that they each submitted a use of force report that inaccurately described the fellow police officer's use of force on a suspect. The Commonwealth now wants to disclose to defendants in all present and future cases in which the officers may testify written notice that they were granted immunity as part of the grand jury investigation and that they admitted to filing a false police report. The Commonwealth's position that it is compelled by Brady to disclose the grand jury information to defendants in unrelated cases finds no support in the case law and would represent a radical expansion of prosecutors' disclosure obligations under Brady. Indeed, I have not been able to locate, and neither the Commonwealth nor the amici have cited any case from any jurisdiction that has held that Brady requires a prosecutor to make wholesale disclosure to defendants in unrelated cases that a police officer witness engaged in dishonest behavior or other misconduct in an unrelated matter. The Commonwealth's position also ignores the long-standing and well-founded policy that grand jury proceedings are to remain secret, as well as the plain language of the immunity statute that the petitioner should not be penalized for providing their immunized testimony. As the Commonwealth's position rests on the premise that Brady mandates the requested disclosure, and as Brady does not, considerations of grand jury secrecy and avoiding penalizing immunized testimony control, and this court should reverse the Superior Court's allowance of the Commonwealth's motion to disclose in unrelated cases. The single justice has also reported a second question concerning the request to disclose the same information to the officer's employer. There is no claim that the Commonwealth has a legal obligation to make such disclosure. Given considerations of grand jury secrecy, and given that the disclosure will penalize the petitioners for their immunized testimony, this court should leave undisturbed the Superior Court's denial of the Commonwealth's motion. Lastly, this court should rule that Criminal Rule 5D does not provide a prosecutor with the authority to disclose grand jury materials to defendants in unrelated cases without judicial approval. With that, I welcome questions from the panel.
Hey, before we do that, I hear some background noise. If anybody has it on speaker, could you take it off speaker or put it on mute, because we want to diminish the background noise. And with that, I'll turn to Justice Lenk.
Good morning. You know, it's a curious position for defense attorneys to be taking, isn't it? Not that they should limit disclosure to defense attorneys. Isn't that a peculiar position to be taking?
Yes, but we're not a criminal defendant in this matter.
I understand that. I'm just saying that, you know, it's just an odd position for a criminal defense attorney to be taking, to be against disclosure to other defense attorneys. And I'm trying to figure out how much this has to do with the fact that you're talking about a grand jury proceeding as opposed to, suppose in open court a judge found a police officer's testimony to be perjured. Would the district attorney's office not have an obligation to make it clear in future litigation involving that police officer's testimony that the police officer had been found to have perjured testimony?
Well, I don't think that since the officer would not be convicted or even charged with a crime under that scenario, that the prosecutor would be obligated under Brady to make that disclosure. However, because there's a policy that encourages prosecutors to err on the side of disclosure, that I think a prudent prosecutor probably would and should make that disclosure. Even though I don't think it would be mandated by Brady, because it wouldn't necessarily be material in a future case, the prosecutor prudently should probably disclose that.
Why should that be the case? What would happen with that information, do you think, in other prosecutions, if it was disclosed? What do you think it would be used for? Impeachment, don't you think?
Well, I think a defense attorney probably would want to use it as impeachment. Whether the defense attorney could effectively impeach the police officer witness, frankly, I'm not sure. But if there's no conviction, no crime, and a Superior Court judge just declares that the officer was lying on the stand, I'm not sure whether that would come in on evidence. I'm not sure what rule of evidence that would come in under. Perhaps it would. But
could he? Let me ask it a different way. Do you think the defense attorney could put that police officer on the stand again in a different case, knowing that he's been or she's been thought to have perjured herself in prior cases?
I may have missed the question. Do you ask whether a DA should put that police officer on the stand?
Yes, that's right. In another case, is the DA free to do that?
Well, I think a DA may not want to. I mean, the DA obviously wants to make sure all, prosecutions are valid. If the DA did, if I were a DA, I would probably disclose that to the other side. However, in terms of does Brady mandate that, I'm not sure, but a prudent prosecutor would disclose that. And from the police officer's perspective, should the police officer's career be ruined by one judge declaring that he was lying without any right to appeal that or have someone review that decision? However, I mean, I think, again, the prudent prosecutor would disclose that. But in this case, the question is, does Brady mandate it? And there's countervailing considerations of grand jury secrecy and immunized testimony that come into play, where in general, if it's just information that may or may not be impeachment evidence, a prosecutor may just want to err on the side of disclosure.
Let me ask you a question a different way. Maybe it's a different question, I'm not sure. Which is that suppose Brady does mandate it. Does the fact that it's a grand jury proceeding or the fact that there was immunized testimony in some way obviate the necessity to do it? Obviate the obligation that otherwise exists under Brady? If there was such an obligation?
That is it's an interesting question. My main argument is that Brady doesn't mandate it, but if Brady mandates it, is there like a grand jury exception?
Exactly.
Frankly, I have not been able to find any case that deals with, let's say, grand jury information, whether Brady requires disclosure in a separate, unrelated matter. And I think there's issues as to whether the prosecutor, should or would know about it in a different matter, whether the prosecutor, whether that's in the possession of the prosecutor. Obviously grand jury materials are secret, so on what basis would a prosecutor in another case find out about it? But I've never found a case addressing that point. And so my position is that the grand jury secrecy would control whether it's just simply a matter of secrecy or whether it's an issue of whether that's not considered within the Commonwealth of the prosecutor's possession. I'm not sure. I've never seen a case that addresses that.
Okay, thank you. I'm done.
Justice Gaziano.
Yes, in the interest of time, I'm sure people you'll get to the distinction between Brady versus Giglio in those federal cases. But let me ask you a more narrow question. When we look at our immunity statute and we look at the immunity that was granted by order in this case, and then you look by analogy or by reference to Carney versus Springfield and the mandate of transactional immunity, all those three sources deal with criminal prosecution. none of them deal with economic harm. And I recognize, of course, that the economic harm could be devastating to a police officer and the police officer's ability to earn a living. But how do we get to your end result when the immunity only deals with immunity from prosecution?
Okay. For one, whether or not the immunity statute comes into play, I think these are grand jury materials that the grand jury secrecy considerations are a factor. But just focus on the immunity statute. Obviously the privilege against self-incrimination just protects against criminal prosecution is broader in mass, as opposed to the federal side. However, the section chapter 233, section 20G, the scope of the immunity granted is obviously broader than criminal matters. There's a couple of provisions. There's one that says a witness who has been granted immunity shall not be prosecuted or subjected to any penalty or forfeiture. And then it goes on to say that the testimony can't be used in any criminal or civil proceeding against him in the court of the Commonwealth. So with respect to the penalty, I think you mentioned Carney. I believe Carney holds that a police officer who is required to make a disclosure, by the police, like an internal affairs investigation, who invokes his privilege against self-incrimination, cannot be terminated on the sole basis of invoking that. So but in this case, for instance, your clients could have, and they didn't. They could have said, "We're not writing anything," and then the police chief could have said, "Yes, you are." And if he had forced them to do so under threat of discharge, they would have been effectively giving transactional immunity, the same endpoint that they got as it played out. Correct? Yeah, I mean, if they had refused, well, I'm not sure. I mean, they did invoke their privilege, and then the Commonwealth overrode it with the immunity grant. If the Commonwealth hadn't, they could not be terminated for invoking their privilege against self-incrimination. So, and to me, that protects them on a civil, not a criminal, but a civil result, and that their job would be protected for invoking their Fifth Amendment privilege. And I think the immunity statute wants to put them in the same position. So by invoking the privilege and then being granted immunity, now the DA's office turns around and in at least our view is trying to get them fired by the police department for their immunized testimony. The statute makes clear, and I don't think it's really been the provision's been interpreted, but it says penalty. You can't be penalized, and I think the intent of the statute is to put the officer in the same position that he would have been in if he had not been compelled to testify. And the DA's office can, I believe they has provided the police department with the video and with their report. The police already has their report, but they have disclosed that. That isn't part of the immunized testimony. But with respect to the immunized testimony, that should not be used to penalize the officer, and I believe that in this case it will be.
Thank you, Mr. Harrington. No further questions.
Okay, thank you. Justice Louie.
Mr. Harrington, you've put much stock in your brief about the Massachusetts law of evidence not adopting specific instances of conduct that show a willingness to be untruthful being available to impeach a witness. So, in other words, that as you reference in your brief, we have not adopted Federal Rule of Evidence 608B, and you also point out that we've said that actually relatively recently in Commonwealth versus Lopes. I guess my it's a two-part question. My first question would be, why is that rule of evidence the parameter in which to analyze Brady? And then my second point is, there may be circumstances where the evidence might be relevant to impeach beyond 608B. For instance, there's a suggestion by a defendant of a forced confession in one case, and you've got analogous situation by a police officer involved where there was untruthful police report in that context, or a case where there's an assault and battery on a police officer, and there's a contention that as here in a previous case that there was untruthful police reports and a use of force report. So, with that said, why are we looking at an evidentiary doctrine to determine the parameters of Brady?
Okay, so under Brady, I think the law is clear that it has to be exculpatory or somehow favorable to the defendant as well as material. So it goes to the material element. Material is under, the Supreme Court cases a reasonable probability that the evidence, if it had been disclosed, the result would be different. And here, because of that, I think you need to assess if this information is given to a defense attorney, let's say in a case where one of the officers was the arresting officer in, let's say, a drunk driving case, what would that defense attorney, would that be material to that case? And I think that you will have to look at whether it's admissible into evidence. I don't think maybe admissibility is the conclusive standard, but I think in assessing the use of that evidence, it should be how is that defense attorney going to use it, and obviously if it's not admissible, it would be very difficult to ever show that it's material. Even in Brady, it basically says that we'll reverse on the penalty because it would have been admissible on the penalty phase, but not on liability. The admissibility of the non-disclosed evidence, or the evidence that should be disclosed, is very important. So, and in this case, I don't believe that there's really the general rule is a pretty strict rule, and I believe the only exception would be, I think on a sexual assault type cases wouldn't apply here on like a previous false allegation. Perhaps there may be some case down the road that maybe this evidence it would be somehow relevant. Well, then the DA would then be in position to perhaps disclose it, probably would want to make a motion to the court because it is grand jury material. But leaving that issue aside, it goes to materiality. I do believe that it's clear that it's not admissible. The Commonwealth, I don't think, even addresses the rule of evidence and the general rule that collateral instances of dishonest conduct is not admissible to impeach under Massachusetts. And I think that would control. And in this case, the Commonwealth is seeking a broad disclosure to basically any defendant in any case where one of these two officers will testify, and certainly, we're saying that should be not allowed. If the Commonwealth wanted to come back with the particular facts of the case and make a motion, then I think that the issue that you raise would be before the court.
Okay, so I certainly understand that you're looking at materiality through the prism of whether or not this type of impeachment evidence would be available under our common law of evidence. The problem is that the defense attorney might not know to make the motion because they don't know about the circumstance. And you reference Commonwealth versus Bohannon, which is the exception for false allegations of rape, and of course there's a significant foundation that has to be shown. But nonetheless, the defense attorney has the opportunity to attempt to be able to lay that foundation. I guess the challenge here is if you have circumstances that really make the police officer's false testimony in another case relevant beyond just impeaching through specific instances of a lack of veracity, and you want to extend Bohannon, the defense attorney doesn't have the opportunity to do that because the defense attorney doesn't know about it.
Well, I guess in my example was the prosecutor would make a motion. That if the prosecutor is looking at it and saying, I'd like to try to disclose this, but it is grand jury material, I'm going to make a motion, and then the prosecutor would say, Judge, this is why I think it may be, helpful to the defense in this case.
And is there a concern?
Broad disclosure. I just think evidence that in all likelihood would not be admissible, in any case, or maybe in almost most cases, it's not mandated by Brady. Secondly, let's say there's a case where you come up with some example why it would be admissible. I still don't think it meets the standard of materiality under Brady, and that I don't think the non-disclosure, I can see why the prosecutor may want to disclose it, but does Brady really require it? Is the non-disclosure of it denying the defendant his right to a fair trial, where the disclosure letter basically says he was granted immunity and admitted to filing a false police report. Is that going to change a case down the road, even assuming that's somehow admissible, which I don't think it ever would be, but let's say it's somehow admissible, that type of, since the case is totally unrelated to the case at bar, I just don't think it would ever be required under Brady.
Well, I think that I'm not going to ask you the questions in the interest of time about Brady looking backwards and how for the analysis. And here we're looking at a circumstance where the information might be available before trial. My concern, and then I'll yield the floor. My concern is that your backup is, well, in a particular case, the DA would be able to disclose because they would see a really heightened relevance to this information, but that requires every assistant DA in every district court to know the information.
Yeah. I mean, part of the main issue in this case, it is grand jury material, so it is secret. So I would think that only the grand jury DA or the prosecuting DA would know about this information, and it wouldn't be widely distributed in the DA's office.
Right. Which is what I'm suggesting is the challenge to your sort of safe harbor as to making sure that if it really is exculpatory, it gets out.
But again, and I appreciate the question. I just think, given the mass rule of evidence, as a practical matter, it's not going to be admissible. The Commonwealth hasn't come up with a scenario why it would ever be admissible to impeach in a given case, and and their position is Brady compels it. Brady requires them to disclose to all defendants in any case they may testify in the future, and there's really no case that at least I can find that has ever held that Brady requires widespread disclosure to all cases where an officer may testify. Now, if the officer obviously was indicted and convicted of a crime that was impeachable under the statute, that certainly would be mandated by Brady. But what the Commonwealth is really arguing is that they are mandated by Brady to make disclosure to all cases where the officers may testify. So our position is that Brady does not mandate that.
Okay, thank you very much. I have no further questions.
Justice Budd.
Hi, good morning.
Good morning.
So I just want to make sure I'm clear on your position. Are you saying that it should be, who should make the decision as to whether or not the information should be disclosed? Are you saying that the Commonwealth should not have even brought it to the attention of a judge because the prosecution should know that this is not something that could be used? Or are you saying that the judge that the prosecutor did the right thing by erring on the side of disclosure and by asking the judge to rule on it, but that the judge made the wrong call?
The latter. I don't blame the prosecutor for bringing the motion to get judicial authority, but our position is that the judge made the wrong call because Brady does not require disclosure. The materials are secret grand jury materials. There is an issue as to, since it's secret grand jury materials, can the judge allow disclosure? And my reading of the cases is there's the federal standard of I'm sorry, I forget the particularized need for the disclosure. In my reading of the cases, that standard really hasn't been addressed under the Massachusetts statute or Rule 5D, and I think there's a real question as to whether grand jury materials can be disclosed aside from a rule allowing it or a statute allowing it. There's a statute that deals with some limited disclosure. Rule 5D deals with exceptions to disclosure. But there's a real question as to whether there is the ability for the judge to even order the disclosure. But I think if the judge does have the discretion, I would ask the court to adopt the federal standard of particularized need. And here, Brady doesn't require it. And even if there's if it doesn't require it, but let's say there's a policy of disclosure on this, err on the side of caution, I still think that the considerations of grand jury secrecy, and it's a strict rule, it's a long-standing rule. There's many reasons why we want to keep, grand jury materials secret. That should control. Also, there's considerations under the immunity statute as well.
Well, just looking at the immunity statute for a second, I'm struggling with how the Commonwealth or the prosecutor's office could order or control any penalties. I know you talked about an immunized witness shouldn't suffer a penalty, but the Commonwealth only has limited control over what it can control, which is prosecution, right? How is it supposed to control what happens outside of that?
Well, the DA's office can disclose. I believe they have disclosed a copy of the tape and submit the report to the police department. But here, and the record really isn't too developed on this issue, but by disclosing that disclosure letter that basically talks about grand jury material, namely that the officers admitted to filing a false police report. That's the DA's description of what happened in the grand jury. That is a disclosure of grand jury material, but it's also seeking to penalize the officers because the record isn't entirely clear, but they are supporting or instituting or at least encouraging a disciplinary proceeding against the officers, and they're supporting it with grand jury materials, and that was immunized grand jury testimony. So our position is that the officers are being subjected to a penalty for the immunized testimony, and Section 20G provides immunity greater than what's constitutionally required, and it would include being penalized for their immunized testimony, and that would be improper.
Well, I think I hear your argument about that, but you also said, I guess, prosecutors are also, I'm not necessarily seeking to penalize your client, but trying to make sure that, the integrity of the police department and the criminal justice system as a whole is upheld. I suppose if that ends up having a negative effect on your client as a penalty, I suppose that's what happens. But putting that aside for just a second, I'm just curious as to, in this particular case, given the fact that there's a video that shows the incident, that the police department presumably, took a look at and we were able to tell, people at the police department were able to tell that your client's use of force reports were false. Are you saying that information also shouldn't be disclosed to with regard to other prosecutions, aside from the fact, because this has nothing to do with immunized testimony or grand jury testimony at all?
I think if it's not immunized testimony or grand jury materials, the Commonwealth is free to essentially disclose what they want. So if they want to disclose it, I don't think Brady requires that disclosure. But again, prosecutors, and for good reason, should err on the side of disclosure. And if they want to disclose things that the defense will be of no help to them, or maybe that they're free to disclose things that aren't the result of immunized testimony, or grand jury materials. So, yes, there's nothing prohibiting them from disclosing that. Whether they should or not, I think that's a different question. But I don't think Brady mandates it, but they're free to disclose that type of information.
Okay, thank you.
Justice Seifert.
Thank you. Good morning.
Good morning.
With regard to the difference between you put out the scenario of testimony in the district court or in the trial court or a superior court, whatever court, where they actually testify on the stand, and you make a distinction. Is that correct, between that and what's going on in the grand jury?
Well, if I understand your question, if these officers, there is an underlying criminal prosecution of an officer called Pessoa, and if I don't know what the status is of that, I know the case is still pending. If that case were to go to trial and the officers were to testify, that would be public, and at that point, certainly that testimony would not be part of the grand jury secret proceeding. So
right.
That's public knowledge.
So it would fall into the category of public knowledge, and theoretically, the defense bar or everybody in the community would know, and there would not be this issue of this confidential information that the prosecutor's aware of that they are not turning over to a defense attorney. So I see these as different kinds of situations. Yeah. My question with regard to the grand jury, though, you argue a lot in your brief that this evidence isn't admissible, it wouldn't be material, but really, that's not the DA's decision, is it? It's really case by case up to the defense attorney to make a decision as to whether evidence is going to be relevant material in terms of its exculpatory nature.
Well, it's the decision of the DA in this sense that the DA's constitutional obligation to disclose evidence under Brady is the DA is required to disclose material favorable evidence, and it's only a violation if the DA doesn't disclose something that the non-disclosure denies that defendant of a fair trial. So the constitutional obligation of a DA is, in my view, more narrow, perhaps much more narrow than perhaps good DA practice of erring on the side of over-disclosure. But because so our view is the DA would not be required unless it's material. And the DA.
But how would the DA know if it's material? If they're not privy to the defense case.
Well, I think it's.
They know this is potentially exculpatory, so it can fall into that category. But it's not totally irrelevant, is it?
Well, it's difficult to assess. Most cases dealing with Brady deal with information relating to the case at bar. The DA's office is saying and this is a very unusual circumstance, we are obligated to disclose information that really has no relevance to other future cases where these officers may testify in. So it's a very unusual circumstances where information that has nothing to do with the case would somehow be material.
So would you be arguing for then, would you be content with a ruling that held that the Commonwealth has to go case by case in front of a judge to request whether they can disclose this?
Yeah, I mean, I would, but I think I'd be more comfortable with saying that there is no Brady obligation to disclose in unrelated cases impeachment evidence unless that evidence would be evidence of a criminal conviction or at least a criminal charge. This is a very unusual obligation the Commonwealth wants to have, in that they're saying we are obligated under Brady to make disclosures in unrelated cases. There are almost no cases on that where...
Well, you say they're unrelated, but aren't they related to the extent that they share witnesses?
Well, I mean, when I use unrelated, I mean a case that the underlying allegations, the incident has nothing to do with each other. So this case at bar is a case against a police officer for violation of civil rights, and let's say there's another case for drunk driving and 6 months against a different defendant. That is unrelated. But yeah, one officer, maybe one of my clients may be testifying in that future case. But I just mean when unrelated, the facts aren't related. Almost all cases, even the impeachment cases that the Supreme Court has dealt with, relate to that case, prior inconsistent statement. So
you would be content if you were trying that drunk driving case, that OUI, would you be content if the prosecutor never told you that they had knowledge that the officer who actually made the arrest had lied in the past on a report?
Well, as a defense attorney, you probably would want any evidence, but I don't know what if you look at that letter, I don't know what a defense attorney would do with that. What would I do if I'm trying that drunk driving case?
I don't know, maybe you would try to strike a deal. What about, let me move on to my last question, and that is, how can the prosecutor put these witnesses on the stand if they don't disclose this? Aren't they in violation of their ethical obligations?
Well, the ethical obligation, I think, is it tracks the Brady language, and that is material exculpatory evidence. And since this evidence doesn't relate to the underlying facts, I mean, just for instance, I can come up with like hypotheticals that a prosecutor may know an officer cheated once, or is having an affair on his wife. That's dishonest. A jury, if they heard that, the jury may say, gee, that really goes to credibility. I don't really believe that officer because he's having an extramarital affair. Does a DA...
And you don't see a difference between that and filing a false police report?
Well, I do see it.
Incident report or whatever it was?
I understand, but I was using an example that's more extreme. But yes, I see it because this relates to their job. However, if you look at it from, gee, what would a jury consider impeachment evidence? There's a wide range of information that an officer would know about himself that if he disclosed to the jury may not want to find him to be believable. And does the officer have an obligation to tell the DA every bad thing about his life in case that a jury may consider that? I mean, here, this is an internal report that isn't an incident report, and it was, the DA calls it false. There's inaccurate information in that. That's what I believe they admitted to. There was some inaccurate information in that, and they haven't been convicted. They haven't been charged with the crime. It's unclear whether there could be even a crime there, and that is not the type of information that can be used for impeachment. And even if it somehow could come in, I don't think it would be. It's not the type. It's so extraneous and remote and vague that I don't think.
Let me ask you another question. Is your position then that Brady material has to be admissible to be Brady material?
I don't think it has to be. I don't think that is the rule, but admissibility certainly is relevant in consideration of whether it's material or not. And there are some cases. Brady's an example. I think there's another Supreme Court case that talks about, gee, that evidence wasn't admissible on that issue. As a result, it's not admissible. I mean, it's not material on that issue. If it's not admissible, there has to be some assessment. How would a defense attorney use it? And it has to have some significant aid in the defense of the case. If it's not
and you'd like to leave that in the hands of the district court prosecutors?
I would like to not have a broad disclosure of information that's unrelated to the case at bar. In my view, it represents a significant departure from a prosecutor's Brady obligations. In my experience, typically Brady disclosures relate to the case at bar, and if the prosecutors are required to make disclosures in unrelated cases of some prior unrelated conduct that's dishonest, frankly, let's say anything in the personnel file of a police officer. Maybe the DA doesn't know that, but the officer knows everything in his personnel file, and the officer, as part of the prosecution team, is the officer required to disclose that? Is the DA required to ask the officer everything in his personnel file, and everything negative is the DA required to disclose in all cases where the officer testifies? That has never been an issue. No court has ever held that. And what the Commonwealth is requesting is an extreme departure under for their Brady obligations to make disclosures in unrelated cases of prior unrelated dishonest conduct by an officer. And I think it would really open up a whole can of worms in terms of exposing officers' complete personnel files to every case where they testify.
Okay, thank you. I'm content.
Okay, thank you, Justice Kafker.
So I'm not so sure that we've decided the issue of whether this is admissible or not. Lopes carefully left open the issue of a police officer testifying falsely, in a matter that impacts whether someone's arrested or convicted or not, right? We were very explicit in that case to leave that open. Correct?
I'm not sure, Your Honor. My memory of Lopes is the facts are similar, but I mean the issue is did the judge abuse the judge's discretion in excluding files? But
the facts there aren't similar, although we didn't get into tremendous detail. That officer was accused of basically, I believe it, taking stolen motorcycle parts for himself. It had nothing to do with his job. And we expressly said it was not related to how he conducted police investigations. This is directly related to how someone conducts police investigations, isn't it?
Well, if Lopes, my memory, and I could be wrong, is that it was an internal affairs investigation dealing with something outside of work. However, the dishonesty was he lied in the internal affairs investigation. So an officer, that is part of his job. He is lying during an internal affairs investigation. The allegations, my client is, he's lying filling out a report, not an incident report, but a use of force report that he really had no obligation to fill out except that his superior told him to. So it is.
The difference is that it may result in the wrongful conviction of somebody. The Dukem and Farak stuff, we obviously, if someone's lying and it impacts on whether someone's convicted, it doesn't need to be in the same case. We've clearly broken down that barrier big time in Dukem and Farak, haven't we?
That's a very unusual case. I understand the concerns there, but I mean, I don't know if I'd even concede. I know the Commonwealth the Commonwealth dismissed these cases against the suspect, but I don't think the court should infer that those were false allegations against the suspect. I mean, I know one of the charges was an assault on a neighbor prior to the police arriving, and they dismissed that. So I don't know whether these allegations are, the false report or the inaccurate report is supporting inaccurate charges against the suspect. It's simply it dealt with the force applied in making the arrest.
Sorry, go ahead. Mm-hmm.
I understand Lopes is somewhat distinguishable, but the Lopes case really first addresses the general rule. You can't impeach with respect to unrelated acts of dishonesty, and then they kind of talk about the facts, and some of the facts are a little different in that this was in this case, that was an internal affairs investigation about something outside of work, but he did lie during the internal affairs investigation. So there are some distinguishing facts, but the general rule, Lopes applies the general rule and makes clear that I think they said like the exception is very chiseled, and that deals with a sexual assault, false allegation. They applied the general rule and then concluded, well, the judge didn't abuse the discretion. But there's nothing in Lopes that would suggest that this type of information would be admissible under the general rule.
And my last questions are different, which relate to the discipline, the issue of penalty and forfeiture. So is it your view that when they provide this testimony, they are now immune from discipline for this incident?
No. I believe that there is transactional immunity from criminal, but then there's some civil protections under the statute as well. And the civil protection would be that they can't use the grand jury immunized testimony against them civilly. I think
although our language is broader than that, right? It says you're granted immunity from prosecution and not be subject to any penalty or forfeiture with respect to the transaction, matter, or thing concerning which he is compelled to testify or produce evidence. So when you say they can look at the video and look at the report, the original report, they can then discipline your clients based on that without running into this penalty or forfeiture provision? Because one thing I'm trying to understand is you say your client shouldn't be put in a worse position because they are compelled to testify. But I'm trying to make sure they're not put in a better position because they've testified.
I see the language of the statute. I see, the beginning of the statute does appear to be transactional, but the interpretation of that statute that we're asking for is the penalty with respect to like a non-criminal penalty would simply just be like a use immunity. And there's other language in that same paragraph about not, using the testimony, evidence in a civil proceeding. I know this isn't it's not a court of the Commonwealth, but looking at the intent of the statute, I think the overriding intent is to give transactional immunity as well as broader, use and derivative use immunity on the civil side as well. That's our reading. I don't think there's really any case that interprets the statute in the non-civil context, but there's very few cases that interpret it anyway. But there is the penalty. I believe that the clear intent of the statute is do not penalize the immunized, the person for having immunized testimony. And here, if he had invoked the Fifth and the DA did not provide him immunity, then they could not use his invocation of the Fifth to terminate him. So,
thank you. That's all I have.
To Chief Justice Gantz, I don't understand why the fact that he received immunity bears on whether or not it would be appropriately furnished to defense counsel. The immunity statute only speaks about no testimony concerning said crime shall be used as evidence against the witness in any court. And if it's in a separate case, it's not being used against the witness because the witness is not on trial.
I will concede that the immunity statute applies more on the second question, the so-called employer disclosure motion. But with respect to the motion to disclose to defendants in unrelated cases, principally our argument is Brady does not mandate it, and even if it does, considerations like grand jury control. With respect to the immunity statute, I understand that they're not going to be, these witnesses aren't going to be parties to any criminal or civil case where it's going to be used. So, I think the penalty, the argument would be that disclosing to every case that they may testify to in the future is, as a practical matter, will penalize them because it will, it perhaps will result in them getting terminated or not be used as a witness in any criminal trials. So that as a practical matter, that will be a penalty. But principally our argument is grand jury, this is grand jury material, it's secret, it should not be disclosed. And Brady does not mandate the disclosure.
Now that segues into the next question is, how can a police chief not be told about this? If you don't prevail on the first argument, and indeed it is viewed as Brady and it is disclosed, and it may be that DAs do not want to use those officers as witnesses, and that if they do testify, they will get cross-examined and may potentially risk the entirety of the case. How can the police chief not be told about that?
Well, with respect to the second motion, our position is grand jury materials, but the DA's office is free to provide non-grand jury materials, any materials that weren't the result of the immunized testimony, and they have, and that's my understanding at least, that they have. So, and if it's a scenario where this court rules that this disclosure should be made to every defense attorney in Bristol County, essentially, well, the officer, the police department would know about that as well. But what the second motion is requesting is essentially what the officer testified to in the grand jury, and in our view, that is secret. There's really no exception to disclose that. And if the officer were to testify at the criminal trial, then it's no longer grand jury material. That's a different issue. But with respect to the issue here, they want to disclose grand jury material that's secret, and there's really no compelling need, as the Superior Court judge found. There's no compelling need because the police department already knows about it.
Yeah,
that's what the judge ruled.
The issue before us is the single justice's question. It's the Commonwealth has not appealed, and we'll hear from Ms. Stern, but my understanding is that they have not appealed the judge's finding with regard to Part 2. So we're dealing with the hypothetical whether there is any bar to disclosure to a police chief, not whether or not the judge erred in this circumstance. Is that correct?
Yes, and I understand that. And so with respect to that, I would ask the court to rule that with respect to secret grand jury materials, with respect to, let's say, a public official that has admitted to engaging in conduct, can the DA's office disclose to the public employer? I don't see an exception to the grand jury secrecy rule. If the court were inclined to make an exception, I would ask that in that circumstance, the DA's office shouldn't be able to do it on its own, make that disclosure. It should go to court and say, we want to have violate the grand jury secrecy because we think it's very important that we notify the employer of this grand jury material and have the particularized need that the federal courts show. And under that, certainly depending on the case, there may be some strong public policy considerations as to why that information should be disclosed.
My last question relates to the scope of what you're asking with regard to grand jury disclosure to defense counsel. I mean, DAs all the time disclose grand jury information to defense counsel in that and related cases. Is it your view that every time they do that, they have to go to a judge?
No, because the DA's office has been authorized by Rule 14A to make that disclosure. It's our position that grand jury materials are secret, except that there's an exception, and there are some exceptions. There's a statute, 268.13d, which provides some exceptions. There's Rule 5d that provides exceptions with respect to the grand jury prosecutor, and there's Rule 14a that makes that requires basically the DA to provide all the grand jury minutes of that case and basically anything relating to the testimony of that case. So I believe the DA does that under rule authority.
So if there is a related case involving a witness which raises serious issues as to the integrity of that witness, your view is they could not disclose that without going to a judge. Is that your argument?
Yes.
I have no further questions. Any questions of my colleagues before we let Mr. Harrington go?
I'd like to follow up, Chief, if I could, on the last question you asked.
Yep.
So if there's a Bohannon issue, you've got a rape case, and the DA is aware, Commonwealth versus Jones prosecution, they're aware of Commonwealth versus Smith with the same alleged victim, and it's clear to the prosecutor that the strenuous foundation required for Bohannon is going to be satisfied, and the DA has a obligation in another case to turn over those grand jury minutes. Are you saying that the DA nonetheless can't turn those over without going to the judge?
I don't know the answer to that question. I just Rule 14A talks about the grand jury minutes in the written or recorded statements of a person who has testified before the grand jury. My understanding of the meaning of that is it relates to the case or the subject of the expected testimony. So I will admit I'm not terribly familiar with that Bohannon and the protocol under that case. I think it's and in my experience is that perhaps the DA makes disclosures of grand jury minutes that may be broader than what the rules authorize, but it's our position that with respect to a grand jury testimony of an officer witness, to disclose that to every case that the officer may testify to, where the grand jury testimony has nothing to do with his expected testimony in that case, that would be extremely broad, and I don't see any authority under any rule or statute that would provide that. And I think the better avenue would be for the DA to seek authority from the court.
Thank you.
Thank you. Ms. Stern.
Good morning, Your Honor. Shoshana Stern for the Commonwealth.
Exiting.
William Harrington.
Oops, I believe we've...
Should I wait till he comes back or continue?
We've lost Mr. Harrington. Do we still have Edward Harrington? All right, but wait a minute. I would think he'd want to hear what you had to say.
Could we send him an email or something?
Sorry?
Could we send him an email or something? Maybe he doesn't even know he's off. Well, that's not true. You would know he's not hearing anything, huh?
Maybe Fran could call him.
I'm working on it.
Now joining
William Harrington.
All right, welcome back, Mr. Harrington. Okay, Ms. Stern, you may begin.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. As I've expressed in our brief, the Commonwealth's biggest interest in this case is that we want clear guidance on what we do in these situations so that we can act appropriately in all situations and fulfill all of our obligations appropriately, both because there are collateral consequences to getting them wrong and because we want to get them right for their own sake. This case obviously has its own specific facts. In addition to this may differ in some ways to, the full array of cases on a fairly similar fact pattern that could come up. In this case, possibly relevant to both sides, there's not, as my understanding, that there's a lot that is known outside of the grand jury records in the sense that, there is a video that shows that what is in the reports cannot be true. The officers spoke to the DA's office in front of members of the department before they spoke to the grand jury. That was after they were immunized, whatever, to the extent that that has relevance, but the department was present for that interview, members of the department. So the specific sharing of information here, there's not a question of does anybody know or does anybody not know that this happened. And again, that could cut against either side on the particular facts of this case. When the judge below denied our motion to disclose to the police department, her reasoning was significantly that she thought that there was enough that was already known. Which doesn't decide what the issue is, what the rule of law should be in that case. But this is a particular situation where there happens to be a lot that is already known or knowable and not behind the wall of grand jury secrecy such that it has relevance. Again, since insofar as our interest is in guidance in a paramount way, if we could write a better letter in a future case, we'd be happy to hear how we could write a better letter. We'd be happy to write a better letter. We don't think that the ruling in this case, again, whatever happens with regard to these witnesses should turn on sort of the particulars of the case in front of the court. We're interested in global guidance to the extent that this court is willing to give it to us. And I would turn it over for questions.
Justice Sling.
Yes. Okay, I guess my first question really has to do with how much of this do you think is a Brady obligation, or is that dependent in any way in connection with the? How would you have treated this if it were not immunized? How would you have treated this if it were not grand jury material? Would the underlying information about lying by a police officer be something you would regard as a Brady obligation to turn over?
I think we absolutely would, and I believe there is a case. I haven't seen Giglio letters on it, but and first of all, Pessoa wasn't immunized, and we're certainly disclosing him. But the officer at the center of this situation. But that I know we sent out a letter, I believe, to the chief of police, that a form of it public from a different department saying, we investigated this officer, we haven't done any criminal conduct, but we feel like we did find inconsistencies that need to be disclosed to, defendants in cases he's been involved with, and we're not going to call him as a witness again. So we handle without any immunity or actual prosecution. We handled that way in that case.
Because you guys were obliged to do so under Brady?
I believe so, yes.
Okay.
That is our understanding of our Brady obligation.
Okay. And so the question then is whether or not being immunized makes a difference and whether or not it makes a difference that it's grand jury material.
Yes.
And what do you say about whether or not it makes a difference as to whether or not it was immunized?
I don't see how it can, insofar as the primary interests in Brady are the third-party defendants. I don't see how it affects their interests at all. How it can affect. I don't see how their interests would change, and therefore I don't see how it could change the analysis of what should be disclosed. Obviously, we're in the sort of position of being in the middle. We're not the third-party defendants, so we're not in the best position to advocate for their interests and know what those are. But I think that my understanding of Brady, from my review of the case law, is that it is drawn in so much abundance of caution language because you really cannot tell frequently. You can't always tell even if you're being really thorough, but that is what it is. But you can't, particularly the prosecution, that you can't look ahead and see what will be material and that you can't, and I mean, certainly, again, there is a trend, as Justice Casper, I believe, brought up with the Faraq litigation, that you can have situations where information in the AG's office was prosecuting Faraq. They had information that was possibly privileged with regard to Faraq. They were not prosecuting any of the third-party defendants, but boy, was it ever relevant to their cases, and was it ever an issue that it wasn't disclosed as soon as it could have been in those cases where it wasn't even the same immediate prosecuting authority. So you can get very broad, very strong relevance there. And Brady has evolved over time. And I mean, the earliest language is not as broad as it is now, but, and as I note in my, brief, grand jury secrecy has also evolved. You have case, that originally the defendant needed to make a specific case as to why he got his own grand jury minutes, and it evolved by steps after that. And one thing that this court said in Stewart, in changing that by rule of court to say that the defendant gets at least the grand jury minutes of witnesses that are going to testify at trial, was to say that having the judge review it and see if it was useful to the defendant is not a great way to do things, because the judge is not the defense attorney. And I think that would apply to both judges and prosecution in the instances.
Okay, thank you.
Just a question about the potentially harsh medicine here. A different case. Suppose you had a 23-year-old rookie police officer who was involved in a car stop, and he finds drugs. The person's prosecuted for possession of cocaine in the district courts. There's a motion to suppress. The companion with the defendant says he never consented, and the police officer says he consented to the search. So we have a credibility determination. Mm-hmm. The district court judge says, I find the companion to be credible. I do not credit the testimony of the police officer. Motion allowed. That 23-year-old police officer effectively cannot testify ever again and needs to find a new job. Is that what happens?
I mean, I certainly would think that any one person's determination of credibility that's based on one person says this, one person says that, that's a very distinct situation from, and I certainly would hope that the rule would allow for distinctions there between a case where something cannot be true. And, I mean, again, you could get into the extent to which it makes a difference in the result in the case, though obviously in that case it would make a difference if the officer was lying. So that would be a crucial fact, but the judge doesn't necessarily, the judge I'm sure is giving it his best assessment of the evidence, but he doesn't have any special knowledge of whether the officer is or is not in fact lying. He just believes it.
And that's the problem that Mr. Harrington brought out, is that, you have a judge, and the judge is basically, like most judges do, like every judge does, doing the best they can, but they don't have a truth meter.
Yeah.
And they're just assessing the witnesses as they testify, and they look at the police officer in the eye, they look at the witness in the eye, and they say, I'm going with witness, not police officers. And there's no appeal of that. And there's nothing like a video like you have in your case where you can look at that and say, well, it's demonstrably untrue. So if you write this rule and says that it's always giglio, it's always going to be turned over, and the police officer basically is unemployable, is that what we should do?
I certainly think that I would advocate, to the extent that that's a relevant factor, for a rule where the issue is that there's objective evidence of some sort of dishonesty that cannot be true. And I think there's a lot of scenarios in which that can happen other than the witness admitting to it. I mean, in this case, there was video. I mean, you could say, if it comes down to one person says one thing and 25 other people say another thing, that's a sort of blurry, close case maybe. But I mean, there's plenty of cases where something clearly could not be true. And I mean, I think a rule that would confine to, again, situations where it is, it is objectively that what the officer said and it cannot be true, I think would be an entirely reasonable rule. And I mean, obviously, we're sensitive to the difficult position that puts police officers in too. It's just that the constitutional rights of defendants are very, very strong for a good reason. And law enforcement, to some extent, is sort of in that situation where you can't stand on as many rights as you might possibly in other situations, because, I mean, as in the recent case with police mugshots, that you can't have all of the personal professional rights that you might in other spheres because there are other even bigger rights of other people and public trust that override that. And it is what it is.
Thank you, Mr. Stern. I have no further questions.
Justice Louis.
Yes. So you recognize that DAs quite appropriately provide much more information, we hope, than required by Brady, and you point out how imprecise the contours of Brady are with a pretrial analysis. But Mr. Harrington really, on behalf of the appellants, is stressing that not his words, but even if admissibility isn't the touchstone of what is Brady, there has to be some materiality, and that if the evidence is just inadmissible, as a general rule, how do you get to materiality? What's your response to his argument along those lines?
Well, I mean, I think that there's a lot of ways different cases can play out. One thing that Amici pointed out is that, you know, if you know that an officer who participated in the investigation of your client has had a previous record of lying in a professional capacity, you might look extra hard at that, where in a way you wouldn't otherwise. You might find other things that you wouldn't. And so I think that a lot of it might go to investigation there. I mean, a lot of times you might find that there's plenty of corroborating evidence that in this case they were telling the truth, but you certainly want to look into that. And so I think that sort of going to the totality of, you know, what, where would you look? Essentially to look for other information would be a key aspect of that. I think one, not just to say that, well, don't believe this person, but, you know, is there actually a reason in my case where they shouldn't be believed either that might, what can I learn from their previous behavior that might help me analyze my client's case? Okay.
One last question. You reference that there's really no analysis by the appellants about whether a protective order could be effective, and I think that we can look at the immunity implications as completely separate from the admissibility of the evidence, or at least the right to have the evidence provided to defense counsel. They're two different things. Mm-hmm. And I think you speak to the effectiveness of a protective order and litigating the issue of whether it would be admissible under the protection of a protective order. Would there be any concerns about how that would work in the real world, and when we're thinking about issues of open courtrooms and other concerns?
Well, I mean, even with, I mean, part of it is, I mean, again, in this particular case, there's a lot that's generally known. There's been newspaper reports about the general parameters.
Right, but as you pointed out, Ms. Stern, you're really looking for answers from the reported questions, despite.
Yes, Your Honor. So, in a case where, you know, it really was a bombshell of information, I mean, I think that there is. I mean, I think you do the best you can, but I think that, I mean, I think you do the best you can. I mean, I think a protective order has some value, but the fact that you can't make it perfect wouldn't go to the Brady ability of the information, ultimately. And you sort of, you know, hope that officers of the court will do what they can with that. But ultimately, you know, the fact of the information is the most important thing, and we would argue is important enough that we get here anyway, notwithstanding grand jury secrecy, notwithstanding immunity, notwithstanding all of those other things. But the overriding interests are just really overriding.
Thank you very much. I have nothing further.
Okay.
Justice Budd.
Great. Good morning. It looks like, you know, based on what your office did, it's your position that in cases like these, it should go to a judge to make a determination as to whether grand jury information like this should be turned over. Is that fair? I mean, what's the standard for deciding whether this should go to a judge?
We acted as if it needed. We acted on the assumption that it needed to go to a judge when we sent it to the judge, but we also feel that it is there's a basis for arguing that we can do it on our own authority, but we would not want to do that without sanction from this court. So ideally, we would like a ruling that says we can do that on our own authority. I think particularly with regard to the regular disclosure to attorneys in cases where these witnesses were involved, I think that would, again, there's, in terms of being within the prosecutorial function, turning over grand jury minutes is something we do routinely. I think that the case is stronger in that case than with regard to giving it to the public employer. But I think that so that would also be a somewhat more isolated set of circumstances. But yeah, so our position is that we think that there is a basis under the rule for us to do it to disclose in the course of our professional role as prosecutors. But we acted in abundance of caution in this case in taking everything through a judge.
And just in terms of understanding the contours of the rule that you're looking for, you're saying anytime a witness is immunized or has been determined to have lied at some point, what's the rule? Where's the line being drawn when you could turn this information over on your own as opposed to bringing it to a judge?
I mean, I think we would argue that we could, the rule would be that any time that we obtain information showing that a police officer in one of our departments, who would otherwise be a witness for us, has made statements in their professional capacity that objectively cannot be true in the course of an investigation, that we would have authority to disclose that on our own authority for Brady purposes, irrespective of whether some or all of the information came through grand jury testimony.
Okay. And then with regard to disclosing information like that to an employer, do you feel like you should be able to do that as well without going to a judge?
Again, I think it's a closer question, but I think that there is sort of it. I think it certainly is arguably within the scope of our official duties in the same way that our other relevant actions would be. But again, not as directly as providing Brady, which we do all the time, including with grand jury materials.
Okay, thank you.
Okay, this is Justice Cipher, and my question goes to what you have in this case seems to me to be a very unusual situation in that you have the officers admitting that they lied, which is not the same situation you would have necessarily on a witness stand where credibility is being challenged. But here you've got an admission. Do you see a distinction between those two things yourself?
I mean, I think that, in this case, I think that's what the testimony, well, for the purposes of Brady, what it adds to what's already known. But again, this is an unusual case in a number of ways. But again, I think that the crucial fact would be whether there is objective evidence that that the officer lied, whether it comes from them, whether it comes from other irrefutable proof. We have the third officer, or the third bystander officer on the letter, who's not a party to this case. The letter states that he did not testify at the grand jury, but the evidence showed that his statements on the report could not have been true.
Okay. And then with regard to the second issue, I guess I would put these in a category of professional witnesses almost. They're bound to come back. So are other kinds of witnesses in the Commonwealth, such as expert witnesses for sexually dangerous persons, or people like other witnesses like that. Would you look for a rule that would distinguish, the professional witness from the non-professional witness in terms of what could be turned over to the Commonwealth, to an employer?
Well, it's certainly much easier to keep track of professional witnesses, and there's much more. Well, for an employer, I don't know what the Commonwealth's interest would be in non-public employers of civilian witnesses, essentially. That, the police and the drug labs, et cetera, are concerned because they are us. And essentially we are responsible for their integrity. They are responsible for the integrity of the entire justice system, so they play a crucial role there. With regard to civilian witnesses, I don't see that. I suppose there could be a very unusual situation, but certainly our job is not to, look out for everyone's HR department in the Commonwealth.
Right.
And with regard to, I guess it's sort of collateral to what you asked, but with regard to Brady issues, obviously if we got similar information about somebody who was a civilian witness in multiple cases, it would be much harder to reliably keep track of that at this juncture and sort of our evolution of our record keeping. But if we knew about that, obviously we would have to turn that over, and I think there's already a case on that, Commonwealth versus Daniels, at the Amici site for some purpose.
Terrific. Okay, I'm content. Thank you.
Justice Kafker.
So I guess we're in role reversal land today. So is this admissible? This testimony admissible at trial? And if so, why?
I admit I did not look super closely into that issue because I did not think it was actually close to the determining factor on Brady. So I mostly looked at Brady admissibility.
But shouldn't it be important? If we know that it's not admissible, I can see why it's not Brady material. But if it clearly is admissible, it's got to be Brady material, right?
I have trouble seeing how it could not. There could not be an avenue for getting in past professional in the course of conduct, dishonesty on the part of a police officer when they are testifying as a police officer in another case. But I admit I did not sort of, for the purposes of this case, research the nuances of the rules of evidence on this insofar as I feel strongly that the potential significance of the information for analyzing the totality of the case and defense strategy is very strong and in line with many prior rulings, I would say, of many courts about sort of the full picture and the necessity of giving defense counsel the tools to determine what's relevant.
My second question is just your understanding of the meaning of any penalty or forfeiture with respect to the transaction. So, can these guys, can they be, say, from what I understand, you say you turned over the video and the original statements separate and apart from this grand jury testimony. Can they be disciplined? Can they be penalized at work or lose their jobs consistent with that language?
So I know
I just don't understand exactly what. I've always had trouble with transactional immunity, and not be subject to any penalty or forfeiture with respect to the transaction, matter, or thing concerning which he is compelled to testify or produce evidence. So can they be disciplined under that?
My understanding is that police officer employment law is very complicated, and I don't know how, without knowing anything about that and the various, it's the...
I'm not asking you about that part. I'm just asking, what cases should we turn to for the meaning of penalty or forfeiture with respect to the transaction? What are the best guides for that? Because I could look up the employment stuff myself.
Yeah. I mean, I admit I don't know. Amici cited a case where a lawyer, I believe, received federal immunity, which was less comprehensive, and he argued that shouldn't be used against him at his bar discipline proceeding. And this court,
isn't state immunity bigger than federal? It's broader than federal immunity, right?
Yeah. So that was a crucial factor in this court's ruling, though there was some common sense language about how you should, like, if somebody admits to professional unfitness, that there has to essentially be, not that there has to be a way to use it, but that essentially that having to go around that does lead to a strange result. But it's not certainly on point. And Amici didn't find anything, and I am not aware of anything that sort of conclusively explains that. It would be odd if you end up by being immunized in a better position, particularly because, I mean, in this particular case, we're leading this litigation, but there's a number of, we are essentially damaging our own witnesses here. If we wanted to immunize people and have them spill their hearts out at the grand jury so that they would be safe from consequences we don't want them to suffer, that would not be a good result either. So, it seems like that would be potentially subject to abuse if that were the rule.
Thank you. That's all I have.
This is Chief Justice Gans. Just a few questions. In terms of what you're asking us to find, am I correct that you're asking us to find that when an ADA believes that it is in the performance of her duties to furnish Brady information, that under 5, the subsection small d, gives her the authority to disclose it without going to a court?
I think in a case where it falls within a recognized subset of Brady, which we argue that this should be essentially, that it would be. But I think that, we went to the judge as it was because that was unclear. I think we would not want to rule that. I think probably it would. Since Brady in its prudence can incorporate a lot, though I don't know how often even prudence would incorporate other testimony in other cases by people who weren't professional witnesses. But I think it would be that in cases where there is evidence of a professional witness being objectively dishonest in grand jury testimony, that would be a fixed category that we could disclose on our own authority, consistent with our already disclosing grand jury minutes in general.
By a professional witness, it would be effectively a law enforcement officer.
A law enforcement officer, a chemist, somebody from Ode.
Right. With regard to the issue of disclosure to an employer, I gather the issue is not going to be before us what the employer can do with that information, correct?
Yes.
Is that a reason for us to say that should go to a judge before it's disclosed? Because it may turn out that if there is use immunity, the employer may say, I don't want to know about it, because it would make it harder for me to show that I didn't use it.
I admit I hadn't thought about the scenario in which the employer did not want to know. On the other hand, if the employer doesn't want to know and it's important enough, yeah, it certainly should. I think that, again, I take the position in my brief that sort of the employer, it should be presumed that the employer is not going to use information they shouldn't use, but in terms of the employer's position there, at that point it becomes a motion not about whether the Commonwealth can disclose, but whether the employer has sufficient grounds to refuse. Because it's no longer about the fact that it's grand jury, it's about whether the employer wants to be able to show that they didn't know things that they could later be accused of having taken into account, which is a whole different calculus, I think.
Right. I can imagine, I guess there are arguably two. One is that, the see no evil employer who just doesn't want to know about it in general, and there's the second employer who says, I know enough to fire him, but if I get the immunized testimony, then they're going to say that I made derivative use of that information. That's going to complicate the firing.
I mean, and again, I think it also, I mean, it's not necessarily, I think, to be assumed that the purpose of disclosure is purely firing. And in this case, we moved for several reasons, including, internal further training and things, and there could be a lot of useful information in that. I suppose if you did go in front of a judge, they could have part of it disclosed, but not another part. If part was useful for training and part was useful for discipline. But
we don't at this point, we don't know, and I don't think this decision, am I correct, this decision is not going to resolve what an employer can or cannot do with this information.
No.
My last question is purely practical. So there are other cases in which these officers may testify?
There are other cases in which these officers have participated. Whether they testify, again, for the Commonwealth, other than against the officers at the center of this case, I think is an open question.
Okay, so pragmatically, in the time period before we rule, what happens? What do you do with regard to it while you're awaiting us to decide?
Well, at the moment, nothing is happening for reasons unrelated to this case. But otherwise, yes, we have a single justice. We have a single justice stay of our Brady letter. I believe a number of defense attorneys have moved for specific access in their cases to this information, and I believe at least I know several got it, and on a case-by-case basis. And I imagine that something like that would continue. But where they're making specific requests, I think a number of people have been able to sort of read all of the relevant dockets in this case to the extent that they're available and put things together. So I imagine that would continue for better or worse. But it is one reason we wanted the case heard very quickly, to the extent that was possible.
Okay. I have no further questions. Does any other justices have any questions? And hearing none, Ms. Stern, thank you, and that concludes our oral argument.
Thank you.